To the gentlemen who are sitting in the back, if you are interested in commenting on any of our public business, we'd ask that you sign in at the sheet that's at the desk here uh, with your name. And if you'd like to comment, there's a part of the agenda where we'll call for public comment. If not, you're welcome to watch. I just thought if you're here and you do wish to comment, please go ahead and sign the sign-in sheet. And with that, I'll step back. Thank you.
Copies.
Oh, yeah. These are from Pastor King, but they're duplicates of what have been previously circulated with some additions that he'll tell you about.
Okay, everybody have a copy of the material. You got it?
Now, are these duplicates of this or are those from what we would have approved last time?
What you have here, top page is the agenda. Second document is the electronic meeting policy.
Right?
Third is, I guess, third and fourth be a combined document. These are the review office policies. The difference here is that Pastor King has provided a version with commentary. So that's the one difference between what you may have seen previously circulated, and the last are the bylaws. So these have been going around by email. I've made hard copies. Pastor King also made hard copies. I just asked that we use his sets because he was good enough to include the annotated version of his office policies.
And this is the annotated version?
The bylaws, no. The bylaws would be I think it might be the second,
Okay,
the,
would help.
it might be in your, underneath your right hand at the moment, Ms. Ash.
Okay,
Left hand, sorry, I couldn't.
okay.
Sorry.
That's okay. I'm not too good with hands either. Mm.
All right. Good, sorry for interrupting.
Okay.
Is that the city council on the ones and twos? I mean, that's the counselor, the attorney. You work in the meeting, I mean, yeah. Okay.
Do you, have you met Sandra Kennedy, Corporation Counsel?
Yeah. I will now call this meeting to order. The secretary will note the time, date, and the location and the meeting minutes. Madam Vice Chair Monique will be acting secretary until the Madam Secretary is ready to go. Madam Secretary, are you prepared to take attendance?
I'm present.
Girls. present.
Do you want to perform attendance, or would you like the vice chair to act until you're ready?
Yeah, she can act until I'm ready.
Okay,
Thank you.
so all Madam Secretaries will be referred to Madam Vice Chair until you're ready. Let me know when you're ready. Madam Secretary, are you prepared to take attendance?
Yes.
You can do the roll call when you're ready.
Membership list, if that helps.
Rhea Williams,
Present.
Kelly Johnson,
Present.
Bella Webster, Donna Mahone,
Present.
Cheryl Ash,
Present.
Joseph Adams,
Present.
Otis Davis, Monique Thomas, present. In attendance, we have Sharia Williams, Kelly Johnson, Luella Webster, Donna Mahone, Joseph Adams, Cheryl Ash, and Monique Thomas.
We have a quorum. Thank you, Member Secretary. So, looking at today's agenda, I think we've already established that we all have the attachments that were provided to us by the director. And so just to make sure, once again, we have our bylaws, which we're finalizing today. We have our electronic means of communication policy, which we're finalizing today. And we have the review board office policies and procedures of operations which we'll be commenting on today. I first would like to open up this meeting by thanking you all for your service. I understand that we are all volunteers and that there's a sacrifice in order to be here. I would also like to thank our own counsel for the many phone calls that he takes and much work that is probably not billed. And I would like to thank the director for sticking with us from the beginning. And now let's get to work. We're going to first start with our bylaws. While everyone is opening up their bylaws, the chair would like to acknowledge the counselor. Oh my God. No, the common counselor. I am so sorry, and I love her so much, and I can't believe I'm drawing a blank. What's her? I don't call her Ophelia. What's her last name? Gooden. Oh yeah, okay. Counselor Gooden Rogers is in attendance today. Thank you. Okay. All right. So with the bylaws, we are going to consider these paragraph by paragraph. So you all bear with us. And if there's not a volunteer, I'm going to go ahead and take care of this. Article 1, Authority and Identity, Section 1, Name. The name of the board is the Community Police Review Board, which may also be referred to as the Review Board. Section 2, Authority. Ordinance number 10721-20 codified in the Municipal Code of the City of South Bend as Sections 2-12, etc. Created and established a review board. Section 3, power to adopt rules and policies pursuant to 2-12 1.1.15 of the municipal code, the review board is authorized to set rules for its governance and to establish procedures for processing complaints and for ensuring notification to complaining parties of the status and disposition of complaints. Uh, Council, where is section 4?
Should conclude Article 1.
Article 1 has a section 5 on the next page. Or there is a section 5 on the next page. Got it. Is that? Got it. Any discussion? Any discussion? Without objection,
Second, she's having trouble. Oh, she found it. So were we on training or membership?
we're on Article 1, authority and identity.
And what section is that?
It has so
Show
far,
her, show her.
so far 3 sections on page 2.
Okay, we're on Article 1. Yeah, he just finished. Right.
There is a problem with the meeting link, and we would like for all those that would like to attend to be able to do so. So without objection, I'm going to suspend the meeting for 5 minutes. And it is so.
Why don't we take up? Yeah, I think I see what happened. Let's do the ones that I copied.
Yeah.
Because I think I see what happened. That
Okay,
maybe
you guys are gonna give you a different set.
the ones that I think that may have been somebody's
We're not
copier
gonna
was
use
set
those. We're
to
gonna get a different set.
double-sided. The ones that take a look at the ones that I prepared because you'll be able to, I see what the issue is. So you had Article 1 ending in Section 3, and then immediately you saw this Section 5. So that's actually under Article 2.
They're typing out new.
I'll give you mine because mine should be paginated correctly. Thank you
Everyone,
for saying so.
please give the vice chair your old copies. We're going to give you a new copy.
Thanks. I didn't catch that because I'm looking at the ones that I printed.
Got it. Got it.
Take a copy of that. You bet. I think we've gonna,
Do we have an extra? Nope, that was it.
Nope.
Sorry, Director.
actually, this one's good. Well. Thank you for saying something. You're all sitting here staring at me and I'm staring back at you saying, I've got my section too. So I see what happened. It looked like copier settings were off, but the ones that I've attached under those binder clips will have all the correct pagination.
Goodness, I'm gonna need more water.
Yeah.
How are we looking?
Well, or
Is there a way to put these up on the, there?
I think we're going to do that, yes.
Okay.
Ms. Kennedy mentioned it to me a moment ago, so I think.
Yeah, I
we're-
mean, I think,
we'll
yeah,
try
I
to
think
put
it'd
'em
be
up
good
for
to
the-
put it up there.
That a sign?
Mhm. Same one. So this is a new one.
Yes. The
Yeah.
issue with the hard copies was, I think that the printer was set for double-sided copying every other page. So this is okay. Would you mind
Section 5.
going down just one more page so I could take a quick? Perfect. Yep, these are good.
Oh, that was under Article 2. It's there under
You're
Article 2,
on
Section 5.
Article 1.
But we still on Section 1. We just, yeah. Well, we done with Section 1 now.
Saying that section one only, I'm sorry, Article 1 only has 3 sections.
Correct.
Okay, then we're fine.
Did we do the preamble?
The preamble has to be last.
Okay.
We good? Note that we are resuming the meeting. We're still considering by paragraph, which means article in this particular case. Article 2, membership. Section 1, composition. The review board shall be composed of 9 members appointed by the South Bend Common Council who serve at the pleasure of the Common Council. There shall be at least 1 member appointed from each South Bend councilmanic district. Section 2, qualifications. To be eligible to serve on the review board, a member must be current resident of the city of South Bend and must not be sworn law enforcement officer. Council, I apologize. Section 3, terms of office. Each member will serve 3-year term, provided, however, that 1, the initial review board shall be composed of 3 members appointed to a 1-year term, 3 members appointed to a 2-year term, and 3 members appointed to a 3-year term, and members may be reappointed but may not be appointed to more than 2 consecutive terms. Section 4, vacancies and resignations. After a member's term is completed, the Common Council shall appoint a replacement member who will serve a 3-year term or until the member's successor is appointed, but no longer than 60 days beyond the expiration of the term. If a member resigns or is unable to complete a term for any reason, a new member shall be appointed by the Common Council. A new member shall reside in the same councilmanic district as the departing member. If a new member has served 18 months or more of the original term, the new members will be eligible to be reappointed for no more than 1 additional full consecutive term. Section 5, training. I will recognize the member as soon as I read training, Section 5. Section 5, training. All members shall remain current on all mandatory training obligations required by Section 2-12, etc. In addition to such mandatory training, members are encouraged to engage in the recommended training under Sections 2-12.1.14D. Records of training shall be delivered to the Director of the Review Office. If you would like to have discussion, indicate so by raising your hand. Who would like to say something on this? So just me and Member Cheryl, that's it. The chair recognizes Member Cheryl.
Membership and all, the at-large members can be from the same district. I just want to make sure I'm reading this right.
That's what it seems to me.
Okay.
I would, Ms. Ash, I'm sorry, may I?
Yeah.
The chair does not recognize counsel. I know that council created these very carefully, so there should not be any different language, or there shouldn't be too much of a variance when we look inside of things like the review office policies and procedures that we're going to see later. Is that correct, counsel?
We stuck pretty closely to the language of the enabling ordinance. And as to the qualifications for membership, what councilmanic districts from which they are drawn or represent, I didn't depart from the language of the ordinance. Now, like so many other things, it's an ordinance. If it were to change, then we would have some more liberty to change our bylaws. But I didn't think it appropriate to depart from the authority that the Common Council gave us. So I think I will be mindful that it's your meeting and not interject myself, other than to say, I think the answers to so many of those questions as you read these along would be that I stuck as closely as possible to the ordinance and my interpretation of our authority under the ordinance. A good analogy I once got, I think when I was in law school, is you look at something like the ordinance as the Constitution and something like the bylaws as your interpretation of the Constitution, but everything you do has to be constitutional. So to extend the analogy, everything that I have included in these bylaws is rooted in its authority in this enabling ordinance. There are instances in the ordinance where it allows us to do certain things, like we're required to have a president, but we have the option of having additional officers like we do. So the answer, to make it concise, and I hopefully won't weigh in again, would just be to say, if you're wondering the source of authority or where some of these points have come from, they've come from the ordinance, because that is where our authority comes from. And we will respect the authority of the Common Council who gave it to us.
Thank you, counsel.
Welcome.
As we approach almost a year, the issue of our term, I believe, warrant discussion. So, Member Vice Chair, I'm going to move that we put this in as a part of new business for today. There's a second to put as part of new business the issue of our term, each of our terms. We're going to do a voice vote. All in favor to put that a part of new business, say aye. All opposed? All right, and it is so. Without objection, I will move on to Article 3. Article 3, officers. Section 1, offices. The review board shall select from amongst its members the office of president, a vice president, a secretary, who shall be elected annually by the review board. Duties of the office is section 2. A, president. The president shall be the chair of the review board and presiding officer. Call all meetings of the review board to order and preside over all meetings. Appoint all committees and subcommittees and serve as an ex officio member of all such committees and subcommittees. And sign on behalf of the review board all documents authorized by the review board and generally perform all duties as presiding officer. Vice President, B. The vice president shall perform all duties of the president in the absence of the president. In the case of an absence of the president due to death, incapacity, or disability, resignation, or removal, the vice president shall immediately accede to the office of president until an election is held or the incapacity or disabled is removed. Secretary. The secretary shall see that a record of all proceedings of the review board, including a record of attendance, is kept. Attest to the signature of the president on all documents signed by the president. See that the members of the review board are notified of the times and places of meetings. D, delegation of duties. The president may from time to time delegate other duties to the vice president or secretary. Section 3, vacancies. Should an office become vacant by resignation, removal, or otherwise, the review board shall select a member to fill the vacant office. Okay. The member filing the vacancy will serve the remaining unexpired term of the office and may stand for election at the annual election of officers. Notwithstanding any other provisions of this article, the members may at any time by majority vote to remove an officer and therefore by majority vote select a replacement officer. If there's anyone that would like discussion on that, please indicate by raising your hand. Did a great job on that, council. Without objection, I'm moving on to Article 4. Article 4, Section 1, regular meetings. The review board shall meet as often as necessary to conduct its business, but no less than once every 2 months. Section 2, special meetings. A majority of the members may elect to call a special meeting, provided, however, that to allow sufficient time to comply with Indiana's notice requirement for public meetings. The majority calling for a special meeting must give at least 72 hours notice, excluding Saturdays, Sundays, and legal holidays, of the day and time of the special meeting. Section 3, quorum. 5 members of the review board shall constitute a quorum. Section 4, voting. For all matters requiring a vote of the review board, at least 5 members must vote in favor of the item before any action or disposition can be taken. Section 5, executive session. A majority of members may elect to meet in a non-public executive session for any reason for which an executive session may be held under Indiana law. Section 6, attendance requirements. All members shall attend a minimum of 75% of the review board's meetings. Any member who fails to meet this attendance requirement is subject to removal by the Common Council within 60 days of written notice to the member. Section 7, transparency and public access. All meetings, with the exception of executive sessions, will be open to the public and will be conducted in accordance with Indiana public meeting laws. Records of all meetings will be kept by the secretary and published in accordance with the meeting laws. Are there any members wishing to have comments on this paragraph? If there is, raise your hand. Okay, there's me. Council, I saw the 72 hours. The 72 hours or 48?
Thought about this. The 48-hour requirement is our notice requirement to the public, that we must give at least 48 hours notice that we're conducting any meeting. I suggested that as a board, we commit to deciding to hold a special meeting on 72 hours notice to allow a day's time for us to communicate our intention to hold the meeting to the review office so that then the review office can meet the 48-hour publication notice. That's all I was thinking. My thought there was that if we decided on 48 hours notice to have a special meeting, we really weren't giving ourselves much time to publish that meeting. In other words, we decided at noon on Wednesday to hold a special meeting. Realistically, we'd have to publish notice almost immediately. So it doesn't affect our 48-hour notice in terms of our obligation under state law. This would be an internal commitment to say that if we decide on a Monday to hold a special meeting, the soonest we could have it is 3 days later. That allows us a day internally to set an agenda, to communicate the agenda to the review office, and then allow the review office to publish it. It's by no means something that there's no pride in the authorship here. It was just my thinking, having represented several different public bodies, that 48-hour deadline creeps up on you. And so if we decided to call a special meeting, we would be doing it 72 hours in the future, giving us a day essentially to prepare the agenda and to give the 48-hour notice. That was my thoughts there. It's a bit of it's surplusage to the requirements, but it reflects a more practical experience with doing these things that I think that I don't think we're hurting ourselves by having an extra day.
And what of this 75% attendance requirement?
That, Mr. President, is from the enabling ordinance.
Okay, thank you. I'll reconsider if anybody want any questions now that the council has spoken. Is there any members who would like any discussion? Indicate so by raising your hand. Without objection, going to move to Article 5. Article 5, Complaint Review Process. Section 1, Initial Review. After an investigation has been returned to the Community Police Review Office, the Review Board shall review the investigation and the action taken or recommended, if any, by the Chief of the South Bend Police Department. Section 2, Review Board Options. If the Review Board disagrees with the action taken or recommended by the Chief or the investigation conducted by the South Bend Police Department, the Review Board shall notify the officer or officers alleged to have been involved in the complaint. The Review Board may then, by majority vote, A, order the Director of the Review Office to further investigate the allegations of the complaint. 2, conduct an informal administrative hearing on the complaint. Or 3, which is C, order the Director to engage in a process of informal mediation to attempt to resolve the complaint. Section 3, Conduct of Hearings. If the Review Board elects to hold a hearing, the Review Office shall give written notice to all parties and witnesses at least 15 days in advance of the hearing. All parties shall be informed of the right to have legal counsel or other representative or advocate to represent the party at the hearing. All hearings will be conducted in public in accordance with Indiana's open door and public meeting laws. All testimony at such hearings shall be recorded and given under oath and under penalty of perjury. Section 4, Dispositions. Upon completion of an investigation by the Review Office or after a hearing conducted by the Review Board, the Review Board shall make a disposition regarding the complaint. The disposition shall include one or more of the following: not sustained, where there is insufficient evidence to prove the allegations made in the complaint by preponderance of evidence. Sustained, where there is sufficient evidence to prove the allegations made in the complaint by preponderance of evidence. Exonerated, when the allegations made in the complaint are false or not actual and the conduct complained of was lawful and proper and/or withdrawn. When the complaining party requests that no further action be taken on the case. If the review board determines that an officer is exonerated because the complaint is knowingly and intentionally false, the review board shall refer the matter to the St. Joseph County prosecutor. Section 5, timeline and disposition. The disposition of the review board must be made within 60 working days after the South Bend Police Department's investigation, if any, is returned to the review office or after the conclusion of the investigation conducted by the director of the review office. Section 6, disclosure of disposition. The findings and disposition of the review board shall be communicated to the Common Council, the mayor, the Board of Public Safety, and the complaining party within 10 days of the date of disposition. Any members wishing to have a discussion indicate by raising your hand.
Go back.
The member recognizes, the chair recognizes Member Cheryl.
Not sure I know the difference.
I'll refer to council.
Thank you, Mr. President. It's a term of art, probably used somewhat frequently in the legal profession to draw a distinction between hearings that might be conducted by a body like this or the Animal Welfare Commission or a code enforcement hearing, in contrast to, say, a superior felony court.
Okay.
The main difference is the rules of evidence.
Mhm.
When lawyers see something described as an informal administrative hearing, I think what we perceive that to mean is the rules of evidence would be relaxed. It wouldn't be necessary to present the same foundation of exhibits that you might be required to present
Okay.
in a court proceeding. You may be allowed to testify to hearsay, for example, which you could not do in a court proceeding. Small claims court has a similar rule that in so many words says that formalities are relaxed in favor of dispensing with speedy and informal justice.
Mhm.
So when I see that, then that comes from the enabling ordinance, and I take it to mean that although there wouldn't be no rules, people coming before us shouldn't be intimidated or expect to have the same training a lawyer appearing in front of a jury might expect.
Okay.
And primarily it relates to the presentation of evidence. Judge Marnoka, in many, many trials that I tried in front of him, would say, we prohibit hearsay. But if somebody asked you what the weather's going to be tomorrow, you're going to give hearsay because you're going to say, well, the weatherman said it's going to rain, right?
Mhm.
So that's an example of something that I think was meant by informalities is don't expect this to come in and be treated like a criminal court. Expect it to be more like any other city agency or hearing office you might deal with, where we expect it to be less intimidating and therefore more user-friendly.
Okay. My other question is, you mentioned this before, but I don't remember it. Shall, where it talks about if the review board determines an officer is exonerated, et cetera, the review board shall refer the matter to the St. Joseph County prosecutor. Does shall mean must?
It does, and this comes from the enabling ordinance. I will read you the ordinance and you'll see that it mirrors the bylaw. If the review board determines that an officer is exonerated because the complaint is knowingly and intentionally false, The review board shall refer the matter to the St. Joseph County, Indiana Prosecutor's Office for consideration of charges for false reporting or similar crimes under, and then there's a code citation. Mine was a little bit more concise. I took out some of the code citations. But this is an instance where I intentionally did not depart from what the enabling ordinance said.
Okay.
Thank you. Do you yield? Member
Yeah,
Cheryl?
yeah.
Without objection, I'll move on to the final. Nope. Article 6. Article 6, Section 1, Other Duties. In addition to the duties described in Article 5, the review board shall collect, track, and report civilian complaints, suggest revisions to existing or the addition of new policies, facilitate community advisory group meetings and compile resident feedback, provide policy suggestions to the Common Council, Mayor, and Board of Public Safety, and recommend to the appropriate authority the additional investigation of complaints when necessary. Section 2, advisors and consultants. To carry its duties under Article 5, this article, ordinance number 107-20, 10721-20, and other applicable laws, the review board may, subject to funding, engage advisors and consultants. If you would like discussion on this paragraph, indicate so by raising your hand. Without objection, I'm moving on. Article 7, subpoena requests. For the purposes of conducting an investigation or hearing, the review board may, by majority vote, request Common Council to issue a subpoena to witnesses and/or for documents, except those documents relating to ongoing criminal investigations, including such public records as may be subject to disclosure. If there's any desiring discussion on this article, indicate so by raising your hand. Without objection, I'm moving on to Article 8. These bylaws may be amended from time to time by a majority vote of the members. Are there any discussion? Now this preamble. I think we'll pass this first or put it up for a vote, and then we can go to the preamble if I understand the parliamentary procedures correctly. I will now entertain a motion for the passing of the Community Police Review Board bylaws. I believe it's going to be as is, since there was no changes made in the individual paragraphs. So is there a motion? We need a motion. All right, there's a motion for Member Luella. Is there a second? We're going to do a roll call vote.
I'll second it.
Okay. Member Vice Chair Monique has already seconded. We're going to do a roll call vote. Who is acting as secretary? Who is secretary? Okay. Go ahead and call the roll.
Sharia Williams. Are you muted, Sharia?
Yes, I am.
I'll start roll again. Sharia Williams,
Present.
Kelly Johnson.
Hold on. It's a roll call vote. Let me know if you're in favor or not.
Oh, I'm sorry, I couldn't hear you. I'm in favor. Yes.
Kelly Johnson,
Yes.
Luella Webster. Donna McMahon.
Yes.
Joseph Adams.
Yes.
Cheryl Ash.
Yes.
Dominique Thomas, yes.
We have adopted our bylaws. Thank you all. Now we're moving on to the electronic means of communication. We are not going to go by this paragraph, but what we will do is we will have the attorney give us a few words on it to remind us, what was going on. And you all have had an opportunity to kind of look through it. And so if you would like to speak on it or ask any questions, please let me know now by raising your hand. So we have one member. Anyone else have any questions specifically about this? Okay, we have two. Okay, so attorney, I'm going to yield you the floor just to remind us what we're doing, and then I'm going to recognize the members to ask their specific questions.
Thank you, Mr. President. Probably coming as no surprise to anybody that when government started getting back to business, when some of the COVID privations were relaxed, the state legislature provided a means for members of public bodies to participate remotely in the same way I think so many of us in both the public and private sector had gotten used to during COVID. One obligation under state law is that if you are going to allow the members of a public body to participate remotely, that you, as a public body, adopt a policy for electronic meeting. The resolution that is before you, candidly, I did not write. I believe it was prepared by the Corporation Counsel's office, but there's a reason for that. Because it mirrors the standing policies that all other city bodies or agencies have adopted. Please don't let me speak for the Corporation Counsel's office, Ms. Kennedy. If I'm off the mark, please tell me. Thank you. That's a well-made point, because much like with our bylaws, where I stuck very closely to the enabling ordinance, the electronic meeting policy sticks very closely to state law. There are a couple highlights. One is that if we have any members participating remotely, when it comes to a vote, we are required to do a roll call vote. So President Adams, you just did a very able job of demonstrating how to do that, as did you, Ms. Thomas, or Vice President Thomas. So that's one highlight. The second is we have to have at least 50% of our members present in person. Second would be that, or excuse me, third, this is members cannot attend more than 50% of the annual meetings remotely or in a calendar year. So at least half the times we'd have to have people present. The other half, they could participate remotely unless the remote participation is due to one of these four exceptions. Emergencies are good ones. Military service is another one. Deaths or other illnesses or medical conditions. And then the fourth highlight here would be that in the regular course, members are allowed to participate remotely twice in a row. After the second time, they are required to participate in person and then can participate again remotely, unless there's one of these exceptions. So I think we all can imagine a last minute personal emergency, an illness. Dr. Adams, I don't know if you're still in the service or not, but you understand, as do I, in my experience of it, that a military service may be a reason that some future board members might not be able to attend. Those are my highlights. Roll call votes, as we demonstrated with the bylaws, at least 50% present, and we have 6 out of 7 physically present, so we're exceeding our minimum. No more than half the year unless there's an exception, and then no more than twice in a row before reporting in person unless an exception applies. I really have I'm sorry. I guess I have one other point of order that I'd recommend, if you're inclined to adopt these tonight, that you do so with one edit or revision. The resolution that's in front of you is numbered resolution number 01/2024. I think it reflects the fact that this was prepared in 2024. I have brought with me a version for the board president and secretary to sign that I have renumbered 01/2025, and I have changed the date of the adoption to today. Otherwise, I have not changed this from what Corporation Counsel prepared, because I thought it was, I thought, generally speaking, it's good for us to be aligned with what other city boards are doing. This does reflect Indiana law. I have represented other boards that have adopted this. I have been in front of other boards as a attorney that followed these state laws. So I could try to answer specific questions about it, other than to say I think this is a fair reflection of Indiana law, and my only changes to it are just the dates. And we brought this forward to tonight because I think I can speak for Dr. Adams in saying this has been on our agenda for a while, and we'd like to take care of things like this so we can get on to our real business.
Are there any members, I'm just asking again, any other members that would like to ask questions in regards to this? Okay, the chair recognizes Member Cheryl.
Okay. On page 2, the last, under B, the last part of it says, number 2, may participate in a final action only if the member can be seen and heard. So I'm taking that to mean when we have voting, we have to see the person and not just hear them. Am I correct?
I refer to council.
That is correct. What I often see other boards do is that the chairperson, if the member participating remotely hasn't turned their Zoom camera on, would just say, please turn your camera on so we can see you.
Okay.
Do you yield?
I want to make sure I understood what that meant.
The member yields. Member Kelly, the chair recognizes you.
Question B in section 3, specifically .2, illness or medical condition. Would that apply solely to the member, or could that also be, a close relative, family member that I may care for?
The chair refers to council.
I don't, so I'm just going to give you a quick interpretation. I would have to research this further to give you a more full answer. I think it is meant, well, it's not strictly limited to the member himself or herself. I can tell you where I have seen this in a practical sense. I know of at least one public body where a member was undergoing radiation therapy and had to miss meetings for that reason. I suppose I would answer that by reference to B4 under section 3, where it talks about an emergency to persons or property, where that is not limited strictly to the member. My inclination would be to say that if what kept a member from attending was a sudden illness or a threat of harm to a family member, I think the exception that would most easily apply would be B4. I think B2 arguably applies because one thing lawyers are trained to do is consider the absence of words. The absence of words have meaning just as much as the words on the page. And what you do not see here is the member's illness or other medical condition. If it came down to it, I often tell other clients that I'm imagining how I would defend this position if I had to defend it in a court. And I would say exactly that the literal language of this section says illness or other medical condition without qualifying whose illness or medical condition. Now, I'd like to spend a little time researching that to see if there's any interpretation offered by any other legal authorities that say, well, it's implied that it meant the member. But my instant reaction looking at just the words on the page is the words on the page do not restrict it strictly to the member's illness or medical condition.
Question. Why can't we just add?
Member Kelly, do you yield?
I do.
Member yield. The chair recognizes Member Cheryl.
Why can't we just add illness or medical condition of member or whatever you want to call it? Relative, friend, whatever, significant other. Why can't we just add it
Prefer.
to make it clear?
Thank you, President Adams. Well, my first answer to that is because this is a word for word what state law says.
Okay.
And I'm pretty conservative when it comes to sticking close as possible to the authority that we work under.
Mhm.
But I also don't necessarily, as we sit here today, I'm not sure I would concede the point. So let me put it back to you this way. If we did edit the ordinance that way, it may be that we don't need to because my interpretation of it already applying to other people is fair. If you'll allow me, I need to be more conscious of the fact that we do have the Corporation Counsel in the room. If this is an area where I should defer to you, please tell me.
Right. Right.
Then I
Okay.
think that Bob is correct, that's where number 4 comes in.
Okay.
You cannot leave them, it's an emergency that you have to shoot. But I am in favor of that interpretation, and unless there's some interpretation that
Okay.
subject to that, that's pretty much how we interpret it for every other board.
Okay.
Thank you.
Thank you.
Do you yield? Member Cheryl? Do you yield?
That's fine.
The chair will recognize Member Luella.
Accident. Date on the. At their. Pedestrian.
Prefer.
I think that would be a classic example, yes. I think that, my take on what the legislature was doing here was promoting access, not restricting access. So I think it's a useful way of interpreting this is what was the legislative intent? And it strikes me that the legislative intent was to promote public participation. So, Ms. Webster, if you are in a situation where you are in a car crash and you're fine, and your first instinct is, I have a meeting to go to, I think the legislature is, I think you're embracing the spirit of the legislature, which is to allow participation unfettered by the fact that you may be physically unable to come here. So I think a useful tool of interpreting all of these, and we're trying to figure out where do the lines lie, what's, you know, what's outside the chalk lines and what's inside of it, would be what was the intent? I think the intent was to promote ease of participation. So yes, my answer to that particular scenario is you would be exempt. And I don't think that's a particularly controversial position when you consider what we all think the state legislature was probably trying to do here, which was make it easier for people to participate, particularly people who are participating in the face of many other life challenges. Keep in mind, this law was passed in April of 2021 at a time where if you had a COVID diagnosis, you were probably going to be ordered to quarantine and stay inside, or if you had a family member who did. So again, in the spirit of public access, I think that we probably don't need to game out every single scenario we can think of. I think we can answer this question more concisely by saying, is the idea to participate, but some emergency or other thing is preventing me from physically being there? Yes, that would be an exception.
The member yields. The chair recognizes Member Cheryl.
Member Cheryl, could you push your mic up because they're having a hard time hearing you?
Okay, I got another one.
Go ahead.
Okay, can people participate electronically on deciding if a police officer is exonerated, not exonerated, et cetera? Can they do that via electronic format?
Before I refer to council, I want to go ahead and add in my question too with that. If the member yields, so I can add in my question. Is it an absolute must? Because I can imagine that there are some voting that would be better suited by ballot. But if we have one member, online, it seems that if we approve this, we're forced, to have to do a roll call. So if you could answer both of our questions.
Of course. I will answer that one first. If you look at Section 2, subsection C, all votes taken during a meeting at which at least one member participates by an electronic means of communications must be taken by roll call vote. So the answer to that question is yes.
Okay.
We do have to have a roll call vote if we have people participating remotely. And Ms. Ash, to your question, I'd refer you to Section 5, which references 7 actions that a public board may not take, or excuse me, what a remote member may not participate in these 7 actions, none of which are actions that this board would take, at least some of them not for now. Adopting a budget, for example, is not something that we would do, at least as we're presently composed, down to establishing a tax or imposing a tax. With the taxes are, for the most part, established by state law with certain authority passed on to cities and towns. So to answer your question, Ms. Ash, there are seven specific actions that the remote member may not participate in. You will not find in there anything that we do that the remote member could not participate.
Okay.
And I think, again, trying to divine the legislative intent, if you look at the majority of these actions, these are financial decisions that affect citizens. A referendum, a fee increase, a penalty, eminent domain, meaning taking private property for compensation, establishing a tax. I think the legislator's intent there was that those things in particular require all voting members to be present in person. My interpretation, to answer your question, is because there's nothing that we do that fits within those 7 categories, then we could have a member participate in in a dispositional hearing, shall we say, remotely.
Um, I'm very concerned, council. Very concerned. If we pass this, I mean, I don't, maybe it's the case even if we don't pass it, but I almost feel like we need to see the actual code. Because let me give you an instance. In this meeting alone, we have took silent votes. We've done voice votes. And all of that goes away. It's a roll call vote for every vote. That's how I'm reading this as absolute. And I really need to see the Indiana code before we give up our ability to get through issues. Which there is.
But I'll ask to get it open.
The chair will recognize the director.
All right, there are several people online asking for public comment on the bylaws. So they were asking if they could do public comment before you actually voted, but we got too far ahead and we didn't get a chance to do that. So I'm asking if you're open to allowing them to do their public comments.
Okay, according to Robert's rules, we can go back to an issue. I'm trying to see how best to do this. We can go back to an issue that we've already closed. Yes, and we can reconsider it. You would like to? Okay. Let's, who's the last one, before the director got them? The member recognizes.
Please use the mic because they're struggling to hear you guys.
So she posted a valid question, but you weren't able to hear her. I'm gonna let her respond and ask that question because I think that that might be something that we were considering voting on.
My question was, why would we have to go back and open the point if we're just hearing comments?
The reason why the chair suggested reconsidering it is because we voted on it without hearing public comment. So it almost kind of could require a reconsideration, maybe another vote after we've heard the public comments.
Thank you.
Actually, I do think that's appropriate. And also that is what we put out in the public. We kind of let them know that we were going to listen to them, and we do value the public.
Date's wrong.
Yeah, we're gonna fix all that. So this is what we're gonna do. We're going to leave where we're at right now and go back to the last order of business for reconsideration and go right into public comments. But that requires a vote. And if this is the way things are going to be, let's practice.
So you need-
Member Secretary? Yes.
Korea Williams,
Yes.
I'm not sure what we're voting on.
There's a point of order. The member wants to know what we're voting on. We're voting to leave the item that we are on, go back to the one that we just left, reconsider it, and go right into the public, hearing the public portion. And that requires a vote. Yes. Yeah, that's what I was saying. That's what we're doing. We have a roll call vote for that.
So I move we return to the
Oh.
portion of the agenda that discuss, and you tell me what it discussed.
The bylaws.
Okay.
Is there a second? Is there a second? We get the gist of it. There's a second. Thank you, Member Luella. All right, roll call vote for all in favor.
Cheryl, yes.
Cominique Thomas, yes.
Kelly Johnson, yes.
Okay. Joseph, yes.
Sharia
Okay.
Williams, yes.
All right. We're going to be doing that a lot, you all. Yeah, let's get used to that. So now, Director, are we ready for the public comment?
Yes. I believe there's several people online that wanted to have public comment. The one that I can see right now is Joshua Morgan. Joshua Morgan, if you don't mind, please unmute yourself, and you have 3 minutes to make your public comment. Joshua Morgan, are you there? All right. Well, if Joshua Morgan is not prepared to make his public comment, it looks like Kylie Connell has already put up her information here, and we'll move to her and resurface with,
Joshua's there.
okay, I see him coming now. But we'll go ahead and go with Kylie since she's ready now.
Thank you. Just gonna turn on my timer as well, so I keep to the time that's requested. All right, and I will attempt to share my screen. Hopefully this will be visible for all who can see. First of all, thank you for your service to the city of South Bend and the community. I am a city assistant attorney, and I work with the police department. I represent the police department. I hope to foster strong relations between this board and the police department. And to that point, I have prepared some revisions for the board. I'm not sure if you have hard copies. I did give them to Pastor King, and I will also provide them in the chat as well. And I won't be able to go through everything, keeping in mind my time, but this is a topic that I'm very passionate about and I care deeply about. And so I will try to go through as much as I can. Please let me know if you can't see anything or if you can't hear me at any time. First off, there was just a few things of formatting, not really huge issues. I won't even really address those. I'll let you read those or look at those on your own. Another thing to address is the city's ethic policy. That's noted in some of my edits that the board would have to abide by the city's ethics policy as passed by the Common Council. Another point of change that I think is important to note is actually under the secretary section. And I'll scroll down there. It's including what must be in the minutes. This is under the open door law. So this would clearly spell out what has to be included in the minutes. Then going on further, I've made some suggested changes to include administrative hearings in any special meetings definitions, clarifying that official action must happen in meetings and meet the open door laws. That meeting notices will be issued to the public and to the chief of police, and there was an error. I meant to write the clerk, city clerk as well. I included a part for decorum that Robert's rules would be followed, as well as a way to add agenda items. That agenda items would be added at least 7 days prior to the meeting. In my experience with boards, that leaves enough time for administrative preparing of documents and sharing documents that may be needed for the board to review prior to the meeting. I also included a public comment section, which I think is important to put in your bylaws to lay out exactly what can be in public comment and how long public comment will be. I also made some changes to records, that the records would actually be maintained by the review office director, not by the secretary. And this is partially for confidentiality procedures, which I have included later on. Also, I've taken out this entire section of rules and procedures, as we have another document that would govern that. And then the confidentiality section, I think, is very important. It's very important that records are not shared with the public when they should not be shared with the public. And that should be in a bylaw, and that is of great importance to the City of South Bend's Police Department, that's honored. And I do see that I've run out of my 3 minutes, so I will share my edits in the comments, and I will, of course, answer any questions if the board has it. Thank you very much for your time.
Thank you, Attorney Cornell. Donald. Next.
Did you guys have any questions?
No.
Okay, we'll move on to Joshua Morgan. Joshua Morgan, are you ready, prepared to speak? He had some issues with an unmuting earlier. We can't hear you. Still muted, yes. I think you're unmuted now. Okay. All right. Well, we'll come back to you, Officer Morgan. We'll go to Officer Brian Metter, if you have any public comments. Oh, we can hear you now. Are you there?
You can hear me?
Yes.
Thank you, Mr. Director. If the director and the president of the board will allow, I would like to yield my Attorney Kylie Connell so that she could explain a little bit more in detail.
We will allow.
Thank you, Mr. President. I appreciate that.
Thank you. I will continue with my explanation while I pull up my edits again. So moving on, the confidentiality section would be very important to the department and the officers involved. That would include a code section that says that information concerning a city employee's alleged misconduct is not for public access and shall be confidential. So that would mean that any names, addresses, dates, dates, times, locations, anything that could give the public enough information to ask for these records on their own of alleged misconduct would not be appropriate for a public meeting. They could be shared in an executive session, but they would not be appropriate for a public meeting. That would also include reports that are prepared for the board as well. Also, I mentioned that the collective bargaining agreement exists and that no activity from the board should interfere with the collective bargaining. I also made an amendment to the consultants. I felt that that was not completely accurate. The code specifically says that subject to appropriations, that you may engage a consultant for additional information of a specialized police nature necessary to process a complaint. Not that you can hire advisors and consultants for whatever you feel would be appropriate. The director is given a little more leeway to hire, but the board itself is only allowed to have consultants for specialized police nature. I also included a part in the subpoenas relating back to the confidentiality that subpoenas, for the most part, would also occur during executive session, that those would not be made public, that those would not be a part of the public record, because at the time when subpoenas are being asked for, the misconduct is still under investigation. No final determination has been made. Going back to some of the comments that were made, that I noted, there was a question about exonerated, which again, in my suggested, you would take out that entire section and leave that to your procedures portion. I think that would be the appropriate document to have the disposition listed. But a point of clarification is that exonerated does not mean that you have to forward it to the prosecutor's office. That is not what the code calls for. The municipal code says if the board finds that the allegation was knowingly or intentionally false, and actually I think it's an and, knowingly and intentionally false, so that the complainant absolutely that they made this up, then you would forward it to the prosecutor's office. You could still find an officer exonerated without forwarding to the prosecutor's office. So I think my amendments, again, are appropriate for the board to review, and I think they are consistent with other boards as well. Thank you for your time.
Kylie, you do have a few more minutes. Officer Elware gave up his time for you, so you have until 7:27 if you'd like to continue.
Wonderful. Well, then I'll go back through. All right, going back through some of the things that I kind of glossed over. I think it's important that this document be concise where it can be concise and expound upon issues where it needs to expound upon. So a lot of these edits are just pulling things up from down below, giving the board the power underneath this first article, that the board has the power to issue the rules of governance, which is what the bylaws purpose is. It is to be how you govern your meetings, how you govern your board, not necessarily how you execute all of your duties. It moves up the amendment process and the effective date of this document, so that the date of the document is clear, that that's when the document is effective. Taking out this other extra section 2, because most of it was moved up into section 1. I also noted that I think it's important to be consistent with your procedure, that your procedure matches words that are in your bylaws. So if you're referring to yourself as the review board in the bylaws, that should match the procedures. Or if you want to refer to yourselves as the CPRB, that is how you refer to yourselves in the bylaws. While the ordinance gives you the ability to use both names, I think it's better clarity for everyone involved if the board picks one way that they want to be referred to and sticks to that consistently in all documents that are produced. In terms of qualifications, I think it's important to note that a lot of these qualifications are from the ordinance, and a lot of these qualifications have no room for flexibility. They would require a change of the ordinance. They would have to go before the Common Council as an ordinance change for that to be amended. Also, again, moving up the attendance procedure for the membership eligibility and not putting that under meetings. That the members would adhere to conflict of interest and ethics policies. I think that more thoroughly covers everything that I was recommending changes for. So again, thank you for your time. I appreciate it. And we appreciate working with you. Thank you.
All right, I'm going to try one last time to see if Officer Joshua Morgan can make his public comment.
Officer Morgan.
Can you hear me yet?
All right.
Are we good?
Yes.
Oh, great. Joshua Morgan, President of FOP 36. Obviously it's been a while. I've spoken to the council about the Citizens Review Board. I still do have questions, I guess, and as far as the bylaws were concerned, some of it involving under subpoena for an officer to come, like perjury or not. So I guess my questions are, are these interviews or is this investigation or, and I wouldn't even call it investigation, but is the Citizen Review Board going in conjunction with Internal Affairs? Because I think that, you know, trying to, for us, you know, differentiating, you know, Garrity, which is something that, the right that we have when we're dealing with internal affairs, is that going to fall under the merit board as well? And then, you know, some of the other things that I brought up to the council that were never addressed or never given an answer about were IC code 36-8-2.1-2.1, IC code 36-8-2.1-5, and then 36-8-3-2. You know, I brought those up before, never got any answer on them. I would strongly suggest that the review board take Council Kylie's her points under strong consideration before passing the bylaws. You hit a lot of really good, strong points, and I think it would probably assist in your endeavors here. So, thank you.
I don't see anybody else online that wants to make a comment.
So we will close the public comment section. Oh. Is there anyone in person that wanted to make public comments? Okay, on the bylaws. Okay, we will close the public comment section on the bylaws. Because of the public comment section, I will now ask the members, is there anyone by show of hand wanting to discuss this issue? Anyone else? Okay. The chair recognizes Member Cheryl.
In good conscience, vote on this until I actually see the written document myself. You know, I mean, I'm just trying to follow along, but personally, I couldn't vote today in good conscience. I'd have to read the document, see it, think about it a little bit, formulate my questions. So I honestly don't think we should vote on this tonight.
Do you yield? I would like to hear from council in regards to consideration of public comments and our readiness to vote on the bylaws that have been prepared for us right now, with the possibility of amending them later if deemed necessary by our council.
Thank you, Mr. President. So, first, I know that, well, your bylaws are your internal governing documents. I don't think that, so I think, you know, there's nothing certainly wrong with opening the public to comment on these things, although the enabling ordinance wouldn't strictly require a public commentary process for your internal bylaws in a way that it might, or excuse me, that other laws might, for example, with executive office regulations. I'm well familiar with the process of adopting regulations through the federal government, for example, where they're published and called for public comment. I don't think that's strictly speaking necessary for this board to adopt its bylaws to well, I guess the short version is you're not obligated to accept public comment. There's nothing wrong with doing it. With respect to the specific notes on the draft of bylaws that have been before you this evening, I have not seen those notes, so it's hard to comment on them in the time that we have. Procedurally, where you are is you have adopted the bylaws that you took the time to read article by article. You have reopened discussion, and I guess the question to put back to the president is, do you want to reopen the matter of the bylaws and in effect vote to reject the ones that you've just adopted? Do you wish to ratify the ones you've just adopted?
Point of order. The question for council is, our bylaws as they stand right now, are they ready to go? And we can take care of integrating the great comments that we've heard from the public into, maybe some amendments at next meeting.
I see. My answer to that would be yes, that I've written several drafts of these. I've read drafts prepared by prior counsel to this board that I believe were vetted by the Corporation Counsel's office. I was checking. I don't, as we sit here, remember if I shared. No, I did share these with Pastor King and Corporation Counsel's office in advance of this meeting. I feel pretty confident in what you've passed, although I think that I'm always open to suggestion. I'm open to improvements. I'm open to amendments. I'm open to people, be they other attorneys, be they law enforcement officers, be they board members, saying, here's something you didn't think about. This would be a good thing to think about. But I guess I don't find it necessary to recommend to you that you undo the action you've already taken. I think that there might be a more elegant solution, which would be if we could have the written comments that were read to us in advance of our next meeting. I can prepare you an opinion as your counsel about those comments and what amendments may be generated by those comments. But you have passed the bylaws. I'm not in a position to recommend to you, based on what we've heard, that you undo that, so much as we stand on what we've passed, knowing that we can consider amendments once we've had the opportunity to fully digest the comments that were read to us in public comment. That's a long answer to your question, but the simple answer is yes.
In keeping with the chair's strong consideration of each member, I want to ask Member Cheryl, is that good for you? Our council is going to take a look at any and all recommendations, and as appropriate, recommend amendments to us. So,
And plus get a copy of what the lady read.
I have submitted those copies in your packets.
Okay.
Yeah, they're in there.
That the lady,
Yeah.
so just to be on the safe side, we're going to reaffirm our decision. We're going to reaffirm our decision and continue our celebration.
show me later where it is, okay?
Got extras.
Thank you. Thank you.
So there is a motion by the chair to reaffirm our decision and to close this, get back to the business that where we were before we open up for public comment. May I have a second? There is a second by the member vice chair.
Yes.
Okay. Let's do a voice vote. All in favor, say aye. All opposed, say no.
I'm abstaining.
We have one abstain. The ayes have it. Okay. We were. Thank you.
You did miss one of the members in that vote. Oh, she can't, oh, okay, I got you, I got you.
Policy on. Thank you.
Okay, we were in the middle of the electronic policy resolution, which will be resolution number 01-2025. With the date of today, with an adoption date of today. We've heard from our council. The council has also sent us actual code justifying these resolutions. I would like to hear from council again in regards to a very simple question. I know you're looking at the code right now. The question is it absolutely statutorily required for a roll call vote for every issue when one member is electronic?
Is that to me or Ms. Kennedy?
To you.
Thank you. First of all, thank you for sending this. The answer is yes. I'll cite to you Indiana Code 514, 1.5, 3.8. And it is subsection F. All votes taken during a meeting under this section, meaning the electronic meeting section, must be taken by roll call vote. So I think that the author of this electronic meeting policy and I share the same, I suppose, deferential sense of deferring to the higher authority from which our authority is derived. So in this case, this is the state legislature that gives public bodies and boards, including this one, the ability to do this, but they require the roll call vote. So the answer is yes. Thank you, Ms. Kennedy, for the statutory citation.
We're closing discussion, and I will now entertain a motion for the passage of resolution number 0125, participation by electronic means of communication adapted this date. Is there a motion?
Vote on resolution number 01-2025.
Is there a second? Well, I guess this is my last time doing this, but if there are no objections, we'll bypass further discussion and go right to a vote. I just want to ask before we do this, Sharia, are you there?
Yes, I'm here.
Acting Secretary, Madam Vice Chair, please prepare for the roll call vote.
Sharia Williams,
Yes.
Kelly Johnson.
Point of order. Member Sharia, yes to you are in favor of these, of passing this, or yes as to something else?
I'm in favor. For the electronic, participation, correct?
Yes.
Sharia Williams? Yay or nay?
Yes.
Kelly Johnson?
Yay.
Luella Webster?
Yes.
Donna McMahon?
Yes.
Joseph Adams?
Yes.
Cheryl Ash?
Yes.
Dominique Thomas, yes.
May I interrupt you for a point of business?
Is it part of this vote?
Yes.
Okay.
Would you, now, it's passed.
No, 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 it's not. What do you have to say? The chair recognizes the council.
I'm sorry, did you just take your vote? And
What do you have to say?
if it does pass, would you please sign here and have your secretary?
Okay. Resolution, number, 2025 is passed. I trust that I'm signing,
That's the one that I made with the edits that we discussed, just to change the date and the year. And that's why I'm asking you to do this. I'm sorry to impose on your meeting, but since it's just been passed, it requires your signature and the attestation of our, or at least our acting secretary. And make sure that we conduct all our business while we're all together here. And that's also why I stepped down to get my blue pen. So
Thank you.
you're welcome. Thank you.
Council. All right, we are making significant progress. I thank you all. Want to get you out of here soon. Our last order of, our next order of business. Yes, is the Community Police Review Board Office Policies and Procedures of Operation. The chair will recognize the director for this presentation. But before the chair recognizes the director, council, are you prepared to discuss or to inform the board of why this is a requirement? And I'm talking about statutorily, because I would like to get this board to taking care of the business that council has assigned for us to do.
You mean the first two items that we've concluded?
No, the next item on the agenda is the Community Police Review Board
Oh.
Office Policies and Procedures.
Oh, okay, thank you. So these are policies and procedures of the review office. So these are documents that Pastor King has worked on. My understanding, and I will defer to Corporation Counsel, is that with respect to an executive office like the review office, there is a public comment period required for that office to adopt policies. I dealt with this when I represented executive departments when I worked for the city of Chicago. But I think that if you don't mind, maybe better to have the answer come from Pastor King and his attorney.
Well, we have put it up for public comment, but I agree. There's a little different process with ours, so this could be something that we revisit over the 30-day period that it's going to be out for public comment. Yeah. Fair enough. Did you want me to discuss any of it or go through any of it?
The chair recognizes the director and council.
It's pursuant to the ordinance, section 2-12.1.
Point 17, that it requires the rules promulgated by this office to be put up for public comment for 30 days before they can be adopted. And I believe they are on your website. So that where can is there a space for the public to comment on them on the website?
Comment. They can comment on the link from the website.
Thank you, Council. The floor is yours, Director.
Yeah, okay. If you don't really need me to go over anything here, I can answer questions if there's any questions about how the board will, or how the office will operate. If you
Point of
like.
order, is there any members wishing to ask the director questions about this? I know we've had some time to look at it. I know there's one member with a question. Any other members with questions? Any other members with questions? Okay. The chair will recognize Member Cheryl.
Serious misdemeanor. And ABC what?
What section are you in?
Oh, it's B section.
Okay.
I want to know what is the level of the serious misdemeanor? Is it a B, C, B, whatever?
That has not been determined, but a serious misdemeanor or something that's, that will be qualify you not to be on the board. High
But
level.
I want to know what is serious shoplifting?
It could be stealing, it could be shoplifting, something of that nature. But if it was
I want
something,
that more spelled out.
I can look into that. Just say it was 20 years old. That may be different than somebody that just had a misdemeanor for shoplifting.
Right.
Okay. Yep, so we can adjust that. I'll work on that. Any other questions?
I like immediate family spelled out.
Okay. And what section is that in?
It's B on the first page, disqualification for membership. So like immediate family, I'd like to see it say, sibling, spouse, what level of in-laws? Is it mother-in-law, father-in-law?
Okay, it's in there.
Point of order, is the member Cheryl requesting things as an individual citizen or as a member of this board?
Well, I'm requesting that as a member of the board. When you say immediate, to me,
No, I'm going to recognize you in just a second. I just want to know if you're saying it as a member of this board, then this is how we're going to do it. Council, when the board is making comments of things that they would like as a member of this board, then those are the comments of the board. And the comments of the board should collectively go to the director or as a comment to
maybe
this
it's not-
process.
Maybe it's not that. I just want a definition what serious misdemeanor is, that's all. And I want a definition of what is immediate family.
I'm fine with that. I'm absolutely fine with that. But this board will make comments. Yes,
I share you're speaking as board members and I think that any member speaks in his or her capacity as a board member for the board. So I take your point. It may be coming from one individual member, but it's expressing the sense of the entire board.
okay. But I also would like follow-up, which is why I'm bringing it to your attention.
Yes, of course. I think
That makes sense. Does that make sense to you all? This board makes comments. This board will follow up with our comments. That's good? Member Cheryl, I yield back to you.
Yeah, I just want to know what it is.
Right.
Okay.
So a quick answer for the immediate family, it is in the ordinance. So it would be duplicating if I put that in the language of this policy, but If it makes you guys feel a little more comfortable, I can add it in there, reference it. It's in section 2-12, 1.12. And we can always go and add that back in there if you need it.
Do you yield?
Oh, yeah, I'm fine.
Uh,
The thing should be defined.
the chair, I'm gonna need your help, member vice chair. This mission statement, I may need your help depending on what council says. So this question is in regards to, things being the same. Does the review office have the same mission statement as the review board? Are they, and if they are, if council says yes, member vice chair, I need you to check to see if this mission statement is the mission statement that we,
Have a doc-
yeah, that, that we had inside of our, bylaws. So just be prepared for that if he says yes. And so this question is more so related to things being the same, kind of like the commenting attorney made, if necessary.
Thank you. The mission statement that you all have adopted in conjunction with your bylaws, which I have written, mirrors the mission statement under the ordinance, which is the first section of the ordinance, 2:12.1.11. And although the ordinance does not enumerate its missions, I found that as written, there were 4. And so when I wrote them in the bylaws, I enumerated them 1 through 4. The mission statement as described in the review office policies and procedure, they are not the same in a literal sense because it's not the same word for word statements that the ordinance and your bylaws include. But I think in broad strokes, they appear to be a more concise way of expressing the same sentiment. So the answer is no. The review office policies, the review board bylaws, and the enabling ordinance are not the same in their expression of their mission statement. Number one. Number two, the ordinance and the board's bylaws are the same. And then number three, the review office mission statement is in 3 sentences, perhaps a more plain language expression of the mission statement. Now, do bear in mind that I think Pastor King, correct me if I misspeak, but you're under an obligation under this ordinance to publish a draft of your policies and then receive commentary like this.
Right.
So what we're looking at is the draft. It's
That's
not
right.
by any means the final that you have adopted.
That's right.
Okay, thank you.
So I would like to hear from council in regards to the review. I need the review office and the review board are 2 distinct entities, but do they share the same mission, or because they are distinct entities, do they have 2 different missions? Or I mean, I know they may be similar, but I'm talking about.
It's somewhat difficult to answer that question concisely because you're right. The review office is an executive agency department. The review board is essentially a hybrid of a legislative body or created by the legislature, but to serve a judicial quasi judicial function. The ordinance in its mission statement describes the purposes of the board. It does not describe purposes of the office other than in a description of its responsibilities for receiving and acting on complaints. A reference here, section 212.1.16 of the ordinance. I don't know if we should expect them to have the same word for word mission statements. I suppose I wouldn't be surprised if we did, because the same ordinance that created this board also created the review office. But I'm also not surprised that we don't describe ourselves exactly the same, because we serve different functions. We serve the adjudicative function, whereas the office serves the intake and investigatory function. So I guess the answer to that, as concise as I can make it, is they are different bodies serving different aims. Their mission statements wouldn't necessarily word for word mirror each other. And I think this may be, in terms of the review office's mission statement and how it wishes to describe itself, it's really not our purview. So I think the answer is they are different. It may be purposefully so, or it may be that we're all coming at the same aim, but expressing it in different ways. But ultimately, I don't think it's for us to necessarily concern ourselves with how the office may wish to describe itself. That is for the review director to describe as he sees fit.
Are there any other comments from the board members? Okay, because of the way the meeting agenda was laid out, I will ask if there are any comments from the public.
It looks like we have a comment. Officer Elware is giving his time to Kylie. And Kylie, if you're prepared, you'll have 6 minutes.
Yes, I'm prepared.
Okay.
And I will also share my comments in the chat, and hopefully these were also provided to the board as well. And Mr. Masters, I do apologize. I did not have your email to be able to forward these to you. I will forward those as soon as I get your email.
Quite all right, and thank you.
All right, so again, oh, I shared the wrong screen. I apologize. Let's fix that. Again, thank you for your time and your consideration. I appreciate the efforts that we're going through to make sure that we get this right. Because I think everyone involved wants to do this the right way and not have a lot of missteps along the way. So I appreciate your patience, and I appreciate your taking the importance of this entire board. First, I amended the structure of the procedures and policies to just be more readable. I didn't do track changes on this part because it would just be too many track changes. So I included a table of contents and with links that you can just control click and go down to the part that you want to review. As for the mission statement, I absolutely think that the mission statement is the same. If you read the mission statement in the ordinance, it refers to the review board, but it lays out exactly what the board's responsibility is. And part of the board's responsibility is to have the review officer be a part of the process. So I think it is crucial that the mission statement remains the same. If the review office has a completely different mission statement that the board does not agree with, the board should absolutely overturn that, and the board should absolutely have a say. You don't want to, I'm not saying, Pastor King, that you've done this at all, but I'm just saying if we didn't have Pastor King and we had somebody else in that spot, we would want to know that the board has the final say, not the review office director. So I've definitely made changes to the mission statement to be consistent with what is in the ordinance. I've also added some language to refer to the legal authority to even create this procedure and policies. I'm not going to read through every comment. I'm just going to again highlight some of the major things that I think are appropriate. Moving down, as for the membership criteria, I think it's crucial that this actually be taken out. My comment here is that the Common Council appoints, and it's up to the Common Council to determine their criteria for membership. Certainly, I think the board can come up with recommendations for the Common Council to adopt as to what the criteria should be, but I don't think that the board or the review office director has the final say on what the criteria is for someone to be a member of the Community Police Review Board. That's not how it's set up under the ordinance. As for the complaint intake process, I think it's important to note that complaints are supposed to be written. So the option for calling in should not be an option. Absolutely, accommodation should be made where appropriate, but I don't think that having voicemails left on a recorder would be a sufficient form of a complaint. It has to be a written complaint. If that person needs the review office director to come out to their house to do that, maybe that's something the director can do, but I don't think having a phone call or a voicemail is an appropriate method of having a complaint come in. Complaint criteria. I think it's important to note that in the ordinance, that it has to be 60 days after the alleged misconduct. If it's after 60 days, the complaint should not be filed with the board and should not be investigated, absent some extenuating circumstances, such as the person has been in the hospital for that entire period of time and could not have filed a complaint. It would have to be serious circumstances to extend that 60 days. We cannot be investigating, you cannot be investigating complaints that are from 2, 3, 4 years ago. The initial screening process, I think it's important to note that we want to have additional requirements for the screening process, such as what I just mentioned. If it doesn't meet the screening criteria, then the review director can immediately pass that to the board and say, this isn't even a valid complaint, we're not going to investigate this. I would also note that there is some confusion with the police department about what a parallel investigation would look like, and it's not very well laid out in these procedures. Adding some criteria for clarification that it's the internal affairs that does the investigation, that's collecting body-worn cam, that's reviewing the reports. It is not necessarily the review office director who is doing all that. I would also note that there's some discussion of a panel that's wanted, which I would have hoped that that panel would have been included in the bylaws, and it was not. So I would actually recommend that that be completely taken out and that there be no review panel. And if there is a review panel, that there should be some discussion about what that review panel would look like prior to implementing. I also laid out what further investigation would look like and what rights the officers have as involved officers, mentioning the Indiana Code sections, the Garrity warnings, and the personnel complaints policy of the South Bend Police Department. For the review of the actual board, I laid out specifically what the board would be doing once they receive a complaint to review. So after the investigation has finished, the department has made a determination that's submitted to the board for review, and the board either agrees to agree with the determination or they don't agree, and they have 3 options of what they can do. And those three options are the order further investigation, order administrative hearing, or ask for a mediation. I also included what an administrative hearing would look like. Again, I think there's maybe some needed further comment on this from everybody involved, but this is a framework based on other administrative hearings with the city of South Bend, particularly the Board of Public Safety, how they do their hearings and how those are organized. I'm not going to read through all this because it is lengthy, but I would ask you to take the time that you need to review the hearing procedure. This is something that we do want to get right, and we don't want to wing it when we have the point where we want to have a hearing. I would also note that I do have additional protections for officers, in particular when they are called to testify, or if they're called to testify, that they would be given the Garrity warnings, that this would be something that could not be used against them in a criminal case, and it could not be something that essentially they were being compelled to discuss in a hearing, and that could not be later used against them, that this would be a civil administrative hearing. Moving on, again, going about the discovery, how that would look, opening statements, closing statements, laying out exactly what the process would be for that hearing. Also accommodating for an appeal process for the officer, because I believe that if there is a final determination made, the officer would have an ability to appeal any decision. I also laid out a structure for mediation, what that would look like and what that would include. And I would note that I've tried to do my own research and best practices, looking at, I think it was Baltimore mediation, how they do it with their civilian review board, looking at DOJ best practices for how articles that they've advertised for civilian police review boards. And this is what I have come up with. Mediation would be, most importantly, confidential. Anything said in the mediation would never come out to the public and would not go to the board. The only thing the board would hear would be three things. They would hear if there was no resolution. They would hear if there was a satisfactory solution and the complaint would be withdrawn at that point, or if the mediation was not even able to be held. Because what's important about mediation is that all parties want to be there and are willing to discuss and participate in mediation. That's key. We can't force anybody to participate in mediation. And another key point that I'll just I know I already said it, but the important part of mediation is that if it resolves the situation, the complaint must be withdrawn. And that needs to be a part of the structure of the policies. Laying out the case disposition. So that, again, this is after the board has already decided that they don't agree with the department's determination, that the board is now making a final disposition. These final dispositions do not apply if the board agrees with the department's determination. So I added in some language to better track what's in the ordinance. I added in notifications to complainants to better track with what's in the ordinance as well. I also identified some definitions for what the process steps would be called, such as the initial screening phase, pending investigation phase, review phase, and closed phase.
All right.
Preponderance of.
I'm
Thank you.
so sorry.
Thank you for keeping the time. Was there anyone else?
See. It looks like Joshua Morgan would like to give his time to Kylie. So she would have the additional 3 minutes.
All right, 3 additional minutes.
Thank you. Moving on, preponderance of the evidence. I think it's important that the board understands what this definition is and that they all agree on what the definition is. This is a legal definition. It cannot be whatever the board feels like. This is the legal definition. Moving on to confidentiality. This is more specifically for how confidentiality would work in the reports, the investigations, the documents that are prepared for the board and for any kind of hearing or meeting that would happen. Again, it's identifying what should be confidential and what would not be disclosed to the public. Reporting and appeals. It does seem to be a good practice to have an appeal process for the complainants and also for the officers. If it's at a stage where it hasn't gone to a hearing, but an officer wants to make an appeal or a complainant wants to make an appeal, this is what I propose would be the process. I've noticed that a shorter period of time is more appropriate. The longer you give somebody doesn't necessarily mean you're giving them more opportunity. It just means it drags on for a little bit longer and more evidence or more documents are lost along the way. Finally, just some brief comments on the community engagement and transparency. I think there needs to be some more further explanation about what these really would look like and what they really mean and how they apply to the processes. And not just myself, but the police department thinks that there needs to be some expounding on what these things really mean. Electronics meetings policy, this is already covered in your resolution, and I don't think it should be included in your policies and procedures for the process of the complaint. Collaboration with the city. This is also a little bit confusing about how this would actually look and play out. And I think it could use some more explanation in the policies where it can expound. And then also amendments and revisions of this actual policy itself. I think it's important that the public remains a part of this process, including the police department. The police department is not given a spot on this board, but we are a crucial part to the success of this entire process. And we want to be a part of this entire process. And with that, I have concluded the highlights of my recommended changes. Thank you.
Officer Heron did give you 3 more minutes, so if it was something else you needed to cover, you got a couple more minutes.
Sure. Let me just review my notes real quick. Just that I would like to acknowledge that I appreciate the public comment period for this matter and for the bylaws and the procedures. Again, I think it's very important that we allow some feedback. Officers feel very strongly about their rights, rightfully so, and the city feels strongly about its employees and the protection of its employees. And while we also want to hold the community as equally important in any complaints that they may bring, we do want to bring both parties to the table and not forget about the rights of the officers in conjunction with complaints that are filed. I would also just point out it's important that the board continues to follow its documents that are published, notices that are published, and those are things that can be laid out in your bylaws if you feel like more explanation is needed about how those things should look. And again, I just ask for your attention to the suggested edits. These were not made rashly. This is made with lots of thought put in by the police department for a procedure that works for everyone involved to really optimize collaboration between the review board and the police department. So thank you for your attention and time. We are always more than happy to have conversations with the board or even come to present to the board at their request. We would love to be a part of any process that the board would allow us to be a part of. Thank you.
We will close public comments for that section. Now to the board. I paused because we do have a new business item. I'll tell you what, let's take care of the new business item and then I'll open up the floor for, I guess, final comments or anything like that. What? Hold on, we need to close that last one. Let me see. We're not really, yeah, we are doing something. Here's what we're doing. Here's what we're doing. I'm gonna throw a thought out there, guys and ladies. How about you have something?
I can't find new business. Where is it? I lost.
Oh, it was something that we added in, when we first started the meeting. Okay. As far as ending this, so these, this policy has been published for comment. We had the benefit of initial comments. I made a point to the council to collect all of our comments and issue it as the board comments. Is that good? Can I get some type of like some head nods or something to let me know? All right, I'm going to recognize council for a moment.
Thank you. This is a discussion item. There's no action required of this board. These are the internal policies of the review office. And so I think we have to be very careful when we speak about your policies or things that you're doing. What we've just been discussing are the review office policies.
Right.
There's no action required by this board other than to have the discussion we've just had. So I think you can just move on, close the discussion and move on with your agenda. Thank you.
Thank you, council.
Well-
So I'm going to accept what council said and just move on.
Does that mean eventually I'll get answer to B? I'm not sure when he says move on, is it gonna be discussed at another meeting or what?
Move on doesn't mean that you aren't going to,
I'm sorry, I don't mean to interrupt you. It just means there's no need for the board to take any
Any
formal action.
not taking.
We're having a discussion on policies of the review office,
Okay.
and we've heard public discussion of the review office policies. But we couldn't change the review office policies if we wanted to. They're the review office policies. So when I say move on, I don't mean we're not going to answer your questions. I just
Oh,
mean
okay.
we can close the discussion because there's no place for our board to vote here. What Dr. Adams did, and by putting this on the agenda, was allow us the opportunity to have a discussion, which we can close. And I should be more precise in my language. When I say move on, I mean simply on our agenda,
Yeah.
but not as if the matter's decided. In fact, I think there's a 30-day commentary period, and today may be day one. So it will presumably come back for discussion, perhaps at our next meeting.
Okay, gotcha.
I would like to hear from council in regards to the adopted policies, potential impact, adverse impact on this board conducting the business that the council intended.
Thank you. So, I guess I'd answer it this way. I am taking my instructions on our authority and our duties, as well as our authority as a board, from the ordinance. I think that no policy could conflict with the ordinance. I think policies could supplement the ordinance, but not supplant. So, Ms. Connell made a point that I tend to agree with, which is, for example, on member qualifications, where the ordinance says that the Common Council will establish the criteria for membership. The review office could not, for example, adopt a policy allowing residents of Mishawaka to serve, because that would plainly conflict with the ordinance. So it's a question that calls for some speculation. And the best answer I can give you is what we'd like to avoid is policies either from the office or from this board that conflict with the ordinance. I think supplement the ordinance is what we would like to see, but we cannot supplant the ordinance. And as I undertake the project of trying to remember, ask some of your questions, reviewing the comments from council to the police department, that's sort of how I'm going to review them is let's start with what the ordinance says. Does this supplement the ordinance, or is this possibly impermissibly supplanting the ordinance?
Thank you for saying that, counsel. I guess the chair would ask that you would also have a consideration for intent. Strong intent of the authors, intent of the authors of this legislation. Whenever it's possible for that intent to maybe break a tie in your mind.
I agree. I think that is always a useful interpretation tool. So yes, I'm noting that with my notes for myself here about what you'd like to see done.
Okay. We have some new business. I'm going to ask, is there any new business? Vice Chair, you will remind me what it is. Is there any new business? I think I remember. It's the appointments. Time periods. It's the time periods.
I just have one.
Go ahead.
When we get toward the end, which we are, can you give me an idea what we might be looking at for the next time?
The next meeting?
Yeah.
Okay, no problem. I'll try to remember that. I'll try to remember to have that question answered. Okay, time periods. We need to get, the chair would like for us to send the director okay. The chair would like for this board to send the director the terms that you signed up for and or would like. Okay. As we are approaching this first year. This is all the information that I know at this time. Okay. But I would like for this board, the chair would like for this board to send a director for each of us the term that we signed up for and or would like. Okay. I'll remind you to be very careful once I open this up for discussion, but I would actually like a blank sheet of paper because I would like to get this taken care of now. Just need a blank sheet of paper. Okay, so I'm going to send this paper around. All right, and Sharia will take care of you also. I'm going to send this paper around. You'll write your name down and 1, 2, or 3. Now, ultimately, it's the director's decision, but this board will send him a recommendation so that we can make sure that our business is in order and we are able to take care of what council has assigned us to take care of.
Does the year start when we were appointed, or does the year start when we finished all of our training or part of our training, or what?
The chair reminds the member that that is all the information that I have, is
Oh,
that
okay.
we are going to send this. But this is what I will do for the member. We can make a recommendation. We can make a recommendation. This board can make a recommendation. So the chair will recognize Member Cheryl to state what her recommendation is.
I think personally, I went through the academy. I went through one of my ride-alongs. I'm planning on doing another one in April, 2 in April. I'd like to at least have a chance for one case to hear after I did all that. And it was cold the night I did my ride-along.
So what is the member's specific recommendation about when our term should start? Anyone else would like to be recognized while she's writing? Oh, no, she's still, oh, that's Member Luella. Okay, Chair recognizes Member Luella.
There was training that we had to do before we could become an official board. I think the point that when we became an official board, we all but did a ride along because of to me, it was a conflict what the chief wanted and as to what the supposed to do. So once we became eligible for the ride along, that made us an official board. We could officially operate. And I think perhaps that would be the best time to have, to start it as an official board.
Okay, so we
Good
have we have one recommendation. Any more recommendations from the members? Actually, the discussion is open in regards to this topic.
Can I cut in real fast? Not to cut this procedure short, but it is up to the office, and I'm willing to take your recommendations, but ultimately, the Common Council should have alerted you of what your time frame was. So you guys, we could talk via email. You could tell me the term via the Common Council in a separate email. Please don't send it to me in a group email. Yeah.
Um, uh, this paper is going to make its way to you, Council. Member Sharia,
Yes.
can you call the council right now? Do you have his cell phone number?
Yes, I do.
Call him right now and tell him what your term is. This is getting done now.
Okay, give me a minute.
The chair would like to hear from the council in regards to this recommendation that we are about to give to the director right now. Is this something we need to pass? Do we just hand the sheet of paper over? But
Thank you, President. No, this is, so Pastor King is correct. I read the minutes of the Common Council meeting that appointed each member, or, well, not necessarily everyone who's here tonight, but the original board. And it did not, in those minutes, specify which members were serving 1 year, 2 year, or 3 year terms. It gave the authority to determine the lengths of term of the initial board to Pastor King. So what you're providing him is what your preferences are.
And guidance.
which he suggested you do offline by email. I'm also happy to just give him this because it's the functional equivalent of doing that. I have my phone sitting here. Ms. Williams has not rung me yet, but I think that's okay. I don't think you have to take any action on this. This is a discussion item. Other than when you feel like you've exhausted the discussion, you can close the discussion. This is another instance here where the authority is not with us. We're discussing it. You are all expressing your individual preferences, which you've done with your notes here. I think this is something that doesn't have to be done in a public forum. At least you expressing your wishes to Pastor King. I do think it's a good thing we need to address though, because we are coming up on, I think, the 1-year anniversary for some people. So with your permission, I would give your expressions of your interest to Pastor King, and then perhaps Pastor King, if he feels it's appropriate, could include this in his director's report next month. And all I think this board has to do is decide when it's concluded the discussion, and then that would be it.
Is there any benefit to any type of official action on this? I'm thinking in terms of follow-up. I'm thinking in terms of, I'll be very careful, but
Well, I could offer you a suggestion. Why don't we make it an agenda item at our April meeting?
Okay.
We put it under new business, or we put it under a request from the director, that the director respond to the board's expressions of interest for terms. That way it doesn't fall off the agenda, but we also don't take any action on it now until we've had the opportunity to discuss this with Pastor King.
is the vice chair tracking?
Makes sense to me.
That's an agenda item. In a moment, Member Sharia. Okay. We're now ready to close this. No, we're not. Member Sharia.
I think she might have lost connection. She's been trying to get on and off. She's been off several times.
Can she have email Pastor King and you both?
What about just put her on speakerphone? I have you on speakerphone. You're still a part of the meeting. That's okay. 1, 2, or 3. Thank you. I'm hanging up now. We're gonna go ahead and close this discussion. I think that's good. Is there any other new business? Have we taken care of our housekeeping?
Sir President, because this is a special meeting, you really can't add agenda items in this meeting. So we would have to, at some point, close this meeting out because we're extending past the special meeting.
Okay.
Was there any other new business added in the beginning of this meeting? Is that it?
I just like to ask Pastor. I know I've sent you some places to go, and when you go, I'd like to go to some of those places with you.
I would love that. That would be great. Yeah.
Okay, if there is no other new business that was added, then I think that we are ready to conclude.
Want me to make a motion?
I would like to hear from council in regards to our readiness to conclude. That was a lot of stuff.
Well, I think that, certainly, as I understood it, this meeting was called, with some alacrity because we had quite a lot of accumulating business. We had our meeting that was regularly scheduled last week that we had to postpone because we had amongst our board some very sudden issues come up. But that's not the only reason that we've had this business. This is business, these bylaws, the electronic meeting policy. They've been around since last year. And I think that Dr. Adams and your fellow board members, I think that you moved with some speed to get through these so that now when we come back for our regular meetings, we won't have so much of the agenda weighted down by the accumulation of old administrative business, and we can focus on the priority of this board, which is reviewing citizen complaints. So first, I suppose in a long way, I'd say I'd like to, recognize the work you've done and the board has done to get through so much of the work that has been waiting for you and needed to be done so that now you can, as a board, do the task the Common Council asked you to do. As far as this meeting, I share Pastor King's view that we are met in special session to address those things, although we did have a board member comment period, and as it concerns your terms of office, I think that would fall within the board member comment period. However, I have your agenda in front of me. You have passed the bylaws, passed the electronic meeting policy, had your discussion on the office's policies, and had your board member discussion and including a public commentary period. I think you've reached the conclusion of your agenda.
I'll entertain a motion for adjournment.
Adjourn this meeting?
Is there a second? Is there any discussion? All right, is there a roll call vote is needed for this adjournment motion?
Yes. Oh, you're right. So no, we only have members here presently in person.
All in favor, say aye. All opposed? The ayes have it, and we are adjourned.
They have some